hear from the appellant.
Good afternoon, Your Honors.
Yeah.
Scott Hall on behalf of the appellants. My clients are Moytoy LLC, Philip Gettler, Michael McClung, and Darren Gettler. In the briefs, we refer to my clients as defendants or the Moytoy Board. I'd like to reserve 5 minutes, please, for rebuttal. With regard to a statement of the case, I'm going to address the 2 prior appeals that have been filed in this action, and that is, this is the 3rd time that this action has been before the court. Initially, the Haiser 1, which is referred to in the briefs, was the first appeal, and that was brought by the Appellees a few years ago because they were trying to get around joining all of the necessary parties required to address the issues that the appellees wanted to address in this action. The trial court denied class action certification. This court denied class action certification and also made reference to the fact that, unfortunately for the appellees, if they wanted to pursue this action, then they needed to join all those who were necessary parties because class action was not going to be certified. In Haiser 1, which is a 2014 decision, this court stated, "We understand plaintiff's frustration at the prospect of suing and serving potentially hundreds of people. Nevertheless, the requirements of Rule 2301 must be satisfied." Going on, based on the record, quote, the antagonism among proposed class members works to undermine the requirements of typicality and adequacy of representation. This is a case about a community divided, not a group of similarly situated people pursuing the same grievance. So at the end of Haiser 1, the requirement was go back to the trial court and either join those individuals who needed to be joined to attack the covenants that were being addressed, or to leave the covenants alone. They were never joined. Unfortunately, I believe there's a misinterpretation of this court's 2018 opinion, which I refer to as Haiser 2 in the briefs. But the class certification, again, was denied, and the appeal of that class was denied primarily because of the lack of typicality and lack of adequacy of representation. In the 2018 decision, Haiser 2, this court remanded the action back to the trial court for a new trial. I submit the trial court recognized that a challenge to the 2005 amendments was barred by the statute of limitations. This Court of Appeals, I submit, if you read the 2018 decision, which I refer to as Haiser 2, recognized the need to join those individuals if there was going to be a challenge to the 2005 amendments. Now, multiple times in the 2018 action, it was specified by this court that there was not an attack on the 2005 amendments. There was not a challenge to the 2005 amendments. And if you look at the plaintiff's claim, their complaint, which is called the third amended complaint, that's the actionable complaint that was we were here on before, my clients were here on before in the 2018 court decision. And it's the same complaint that we're here on today. There's, number one, no joinder of the parties, but what the defendants did, or excuse me, the plaintiffs and the appellees in this case did, was they tried to attack the 2005 amendments, and I believe, again, the trial court somewhat misunderstood or misapplied Haiser 2, your 2018 decision, and I don't know if any of the three of you were involved in that, but I mean, when I refer to your decision, the Court of Appeals decision, and that's, we're back here today essentially arguing some similar issues, primarily failure to join indispensable and necessary parties to allow this matter to proceed as in accordance with the result that the trial court handed down. Now, just so the court can follow some of the logic and what took place procedurally, it's important to know that after the 2018 decision by this court, the action returned back to the Chancery Court for Cumberland County. Judge Thurman, who had tried the case initially, recused himself, and Judge Davies was appointed, specially appointed. The trial of this action took place December 2020. The facts, essentially, the easy way to describe this in the short time that we have to describe it is essentially a mountain, 9,000 acres approximately, that was purchased, and my clients bought much of that land for the purpose of continuing development on the land. Not all of the land was developed. Not all of the land was platted. There was not a subdivision of all of that property, but there were certain subdivisions. Just like a neighborhood that you may live in or I live in, there's a plat that puts the squares on there to show where the lots are. And there are sections of that mountain that actually have platted areas. There are sections that don't. And the sections that don't were never dedicated to the development. They didn't fall under a homeowners association's ambit. They did not fall under control of any entity. There were no common areas identified on those properties. And that's important here because the last section of our brief, or one of our issues on appeal, is with regard to an encumbrance that the trial court placed upon the property of my client. That property was never dedicated to the development. It was privately held, has been privately held. It was never given to anyone else for any other use or dedicated. And the covenants specifically provide that if there's going to be common property, then it has to be platted or on a recorded instrument. By stipulation, we know that there is no platted common area in this subdivision. By stipulation, we know that there is no recorded instrument that identifies a common property. Unfortunately, I believe the trial court did not apply Haiser 2 as this court intended, and as a result, we're back here. The trial court's most recent.
Let me ask you about that, and maybe I've misheard you, but is it your contention, and did you state that the trial court, that Haiser 2 did not instruct the trial court to determine the validity of the 2005 amendments, that was not something the trial court was supposed to do?
I didn't say that, but the instruction was to interpret those 2005 amendments to the extent that, or not interpret, that may not be a proper word. The 2005
determine whether they were valid, whether they were valid amendments, really.
Well, two things. If that was the case, joinder was required, and the joinder of all the lot owners was required to take place. I submit that the reading of Haiser 2 indicates that the remand was for the purpose, in terms of looking at the 2005 amendments, was to determine whether or not there's evidence in those amendments that conveyed and addressed the conveyance of developer rights. Because in the 2005 amendments, they say that Renegade Resort had developer rights. And Renegade Resort, LLC, was the entity that conveyed via bills of sale of record to my client, Moitoy, those developer rights.
And that's kind of the central issue, is ultimately what the trial court said is there were no developer rights transferred. Ultimately, there was a break in that chain, and so therefore the developer at the time in 2005 that made those amendments could not be valid because they didn't have those rights.
Well,
is that right?
Well, I submit, Your Honor, and the way I read Haiser 2, the only way I can reconcile that issue is that you looked at the 2005 amendments only for the purpose of determining whether they provided evidence. Now, if they were properly acknowledged and prepared, then they provided evidence that there was developer rights held by Renegade Resort, which transferred then the property by bill of sale, no question about that, to Moitoy LLC, who was the developer and operated as the developer up until once it was acquired, until this lawsuit was filed a few months after Moitoy acquired the property. Moitoy, my client, had the property for a very short period. But even before Renegade Resort, there was recordation of the fact that the prior developer, the entity that operated as developer, Cumberland Gardens Acquisition Corporation, had developer rights as well. So Cumberland Gardens Acquisition Corporation transferred the developer rights to Renegade Resort LLC, and then the Renegade Resort transferred those rights to Moitoy. So analyzing...
That's what you argued with the trial court, but the trial court said no, and he had expert proof, I think maybe two competing experts, talking about the nature of what is transferred and the language in the transferring documents, and considering all of that testimony, he made the conclusion that there was no transfer of development. developer rights.
That's correct, Your Honor. But what he did was the trial court did was voided the 2005 amendments, period. And so
Because there was no authority for them.
well, but if you're going to attack those amendments, if you're going to be allowed to attack the amendments for purposes of voiding, then there had to be a joinder. And I know we're running out of time very shortly. This is a big case, but let me, if I may, address the Scanlon decision, which was a decision that we've cited in the case, and also River Plantation. Now, the River Plantation, Your Honor, Judge Swiney, is a decision that you reported. There's a distinction, and I think those two cases provide a good contrast to look at and verify. In the Scanlon, in the River Plantation decision, as Judge Swiney aptly noted, in that case it was just enforcement of covenants. In the Scanlon decision talked about attacking the covenants themselves. And if you do that, then it's a requirement that you join all of the parties that own land and could be affected. This trial judge determined that every one of the owners had a financial interest in the existence or non-existence of the 2005 amendments. Now, there was comment in the record, and I submit that the trial judge was wrong on this, that the homeowners association could represent all the members. I started out by reading the quote from this court about the antagonistic view of all the parties. There's no typicality between these parties. There's no adequate representation that could be deemed to exist with one counsel representing all of the owners, because there is such antagonism. And the trial court in this case went above and beyond what was called for in Haiser 2 and set aside the 2005 amendments, which was said before, you can't do that without joinder of all of the individuals, and class action won't work, and that's what he did. He avoided the amendments. Now, before I leave the stage here, if I may, move on to, I guess, one of the...
You've used your time. You're about to leave the stage until your rebuttal.
Thank you, Your Honor.
Thank you, Mr. Hall. We're here from the Appellee.
May it please the court, I'm Melanie Davis, member of the Blount County Bar, and I represent the appellees in this matter, a number of individuals who live or reside in Renegade Resort and the Renegade Mountain Community Club, which is the owners association for Renegade Resort in Cumberland County. I'd like to just comment at first about the issues raised by opposing counsel. The class action case involved a different operative complaint. The complaint was amended after that case was remanded back to the trial court. At that time, the third amended complaint was filed, and at that point, we did not directly ask for a declaratory judgment to void the 2005 amendments as we previously had done. Instead, we took a different angle and attacked the developer rights of Moi Toi LLC, who is one of the appellants in this case. It was not a declaratory judgment asking that the 2005 amendments be stricken, as it had been previously according to the prior complaint that was at issue when the class action status was sought. So those are apples and oranges, and this whole issue about joinder of parties was brought out throughout that prior case that this court has already decided in the 2018 case. And simply every single time that issue has come up, the joinder of parties has not been required. But continuously that issue is brought up by the appellants because they want to prevent there being an adjudication on the merits in this case. And they know that joining 500 owners is a practical impossibility. So that's what we submit is happening there. Haiser 2, the court definitely said that the complaint, which was the third amended complaint, was not a challenge to the 2005 amendments directly, and therefore it was not barred by the statute of limitations. I'm not really sure where this argument comes from that that's not stated, because it's clearly stated at the bottom of page 12 and the top of page 13 of the prior 2018 opinion. The court previously determined that the validity of the 2005 amendments was not challenged as part of an action in the case at bar. And having determined that, the court stated that the statute of limitations is inapplicable. So that issue, under the law of the case, has already been decided in our favor. There was no request to set aside those restrictive covenants directly. Instead, what the court said last time on remand is you need to determine whether or not those are valid, because Moi Toi had asked as an affirmative defense that its developer rights be recognized because of the 2005 amendments. So one of the tasks the trial court had on remand was to allow both parties to present proof about the 2005 amendments and their adoption and whether or not they were valid. And that's exactly what the trial court did. It did what it was told to do in the scope of remand, and in doing so, found on a variety of issues that those amendments were not valid, were not properly adopted, and wouldn't apply when they were determining the issues in the case. Moytoy could not rely on those 2005 amendments to say that they were the developer and had 10 votes per lot, et cetera. Another issue that was on remand was Moytoy's purported developer rights, and the court determined again on a number of different points that those developer rights did not exist. There was a break in the chain of title where at one point developer rights in 1991, when there was a foreclosure and a substitute trustee's deed, were not included in the conveyance. Only real property was included. And there were experts on both sides on that issue, and there were witnesses who were actually involved in that transaction on both sides who testified. And the court was able to listen to their testimony and decide that from the intent of the grantor, okay, there was no intent to convey any developer rights. There was no mention of developer rights. There's nothing in the writings that covered developer rights, and that simply those were not conveyed. And those conveyances were necessarily needed to be valid in order for Moytoy to have the developer rights it claims today. The next issue on remand was about members in good standing in 2011. The court asked on remand that those be determined. The reason that that was important is that the original complaint asked about the validity of an owners meeting that was held in September 1st of 2011, called by some of my clients in order to get the association up and running. It had not been functioning for a great number of years. The lights had been turned off. There were a number of other problems on the mountain after Moytoy purchased its interest in whatever it purchased in Renegade Resort. It basically appointed itself the board and took over and made life very difficult on the mountain, and thus the owners got together and turned out properly called a special called meeting of the association and elected new directors. The trial court determined that the time period for looking at who was in good standing, who would have the authority to call that meeting and vote in that meeting, was based on 2010 dues. And when you looked at the 2010 dues, the meeting based on what happened was a validly called meeting. The meeting, in fact, took place according to votes where my clients' interests were represented like 5-to-1 over what the developer could vote. Even if they were recognized as having 10 votes per lot as the developer, they still would not have the votes to carry the day based on the minimal number of lots they had at that time. So the court on remand determined that my clients were correct in calling that meeting, and that the association that I represent is in fact the valid homeowners association representing the interests of the community. The next issue on remand was about common areas and roadways. That was briefly referenced by Mr. Hall. What they're trying to do is to use a technicality to try to get around the merits of what is terribly unfair that they're trying to do. There were areas identified on maps, on materials that were passed out to people considering purchasing lots, on association materials, on developer materials, over time identifying a swimming pool area, a sports park, various other areas as common areas. And the Renegade Mountain Community Club dues went to pay to maintain those areas. They were represented as being able to be used by owners. It wasn't something that was open to the public. It was something that members in the association could use because their dues were paying to maintain it. Now, technically, they were never platted, but the trial court correctly looked at the overall circumstances around the history and the promises that had been made about those properties and basically said that there was an easement of enjoyment. And that easement of enjoyment is recognized in every set of restrictive covenants that there is.
The only challenge, I think, if I'm not mistaken, you have with respect to that is the golf course, that it was an error that he included the golf course, that no one intended that to be part of the common area.
That's right. There was some confusion. We had, obviously this was a complex case, and we had a couple of motions to alter or amend the final judgment. There was a discrepancy in what was identified as common area. We tried to get that straightened out. By the time we could file our motion, the appellants had already filed a motion, their notice of appeal. So the court was robbed of its jurisdiction to be able to straighten that out. But it's clear from the record, the golf course was not a common area. The common areas are what was listed in the court's orders as consistently being the common areas at issue in this case. And there was also an issue where the trial court stated in its last order something just kind of on its own, that the plaintiffs had, that my clients had no interest in the golf course. And that really wasn't correct. What had been represented to the court is that nothing about the golf course was being determined in this case. So we would ask also, and have requested in our brief, that that be clarified, that that was never something that was represented to the court by either side, that my client had, the Renegade Mountain Community Club had no interest in the golf course. My client may or may not claim an interest in the golf course in the future. It simply wasn't adjudicated here, and the trial court kind of overstepped when making that statement. We had filed to get that straightened out, but obviously didn't do that in time before the notice of appeal was filed. So we have asked on those two issues.
The trial court never did rule on that?
I'm sorry?
The trial court never ruled on that?
No, we never. The only thing that happened about the golf course was there was a stipulation that the golf course is not, we're not arguing about the golf course. It was owned by a third party who was not a party to this case, and so basically nothing that we were arguing applied to the golf course one way or another, and that was stipulated. But then later, in an order, the court kind of threw in that perhaps dicta statement that the plaintiffs have no interest in the golf course. We don't want that to remain out there in the record, because that's simply not what was presented to the court. The golf course basically just was off limits as far as any decisions by the court in this case. So we'd just like to have that straightened out, since we couldn't do that at the trial court level due to the notice of appeal.
I'm sorry, tell me, why was it off limits?
Just because the people who owned it were parties who were not before the court. It had been sold to a third party, I think the Standing Rock LLC, and this case was complicated enough with the issues that were presented. It just simply wasn't something where we discussed the golf course at any point in this litigation. At one point, it had been owned by the developer, but it had been sold off in previous years, and it was just something that wasn't in the scope of this litigation. So we submit that the court properly identified that the common areas were subject to the easement of enjoyment in equity, more or less, by my clients, given the history of those areas, and that it wasn't fair or just for Moitoy to claim that because prior alleged developers hadn't taken the proper steps to plat the common areas, that somehow the owners have to bear the brunt of that mistake or that oversight. That's not right. What should happen is where money was spent on those areas were represented as being for the use of everybody in the association, those promises should be upheld. Instead, Moitoy put up no trespassing signs, wouldn't let members use those areas, basically tried to claim those as private property after the dispute began with the owners, who I represent. There was also an issue about roadways, and the court made certain decisions about roadways that were correct based on the history presented about use of those roads by members of the community. Some of those roads were not platted, but nevertheless, based on the operation, the use, the money spent previously, the court recognized that there was an easement of my clients on certain roadways, and that was within the scope of the remand. Finally, the last issue on remand was about the special master's report. In the previous litigation, there had been an issue about attorney's fees, and this court ended up hearing the whole case basically again because Chancellor Thurman was recused based on the motion of the appellants after the remand in the 2018 case. So when Judge Davies took over the case, he was new and had to hear all of the facts, probably more extensively than we would have had to have done if Chancellor Thurman had remained on the case. But the determination was ultimately about the special master's report that my clients, in fact, did not owe any attorney fees back, that the attorney fees that were paid voluntarily by owners who wanted to pay extra to help the community, and that those did not have to be repaid. And in fact, the court ultimately recognized that the association dues could be used for attorney's fees, and that association dues payments that had been made from those common funds were appropriately spent and also did not have to be paid back. So we submit that all of these issues on remand are the limit, basically, on what this court should be considering, that the scope of the case should be limited to those issues. If there had been a problem with joinder of parties, that would have, could have, should have been mentioned in the 2018 opinion, and it wasn't. The court gave direction to the trial court to determine the validity of the 2005 amendments, determine Moy Toy's developer rights, with both sides presenting proof of the chain of title, to determine the members in good standing for the 2011 meeting, to figure out what to do with the common areas and roadways, and finally to find out whether the special master's report should be upheld or not, that basically had tried to make my clients pay twice on attorney's fees in the previous case. So all of those things.
The issue of joinder, I mean, was it specifically addressed at all in Haiser 2?
It was not mentioned because it had been mentioned in the trial court a number of times, and the trial court denied it. It did not come up on appeal as an issue. So no.
Simply that no issue was raised as to it?
No, not in Haiser 2. And that's where the direction came. Are the 2005 amendments valid? So if we were supposed to get that determined by the trial court, it seems that the direction also would have included something about adding those essential parties if that were, in fact, a necessary requirement. We've cited a number of cases, Tennessee Supreme Court, Court of Appeals, where developer rights issues have been determined without adding all these additional parties, without adding everybody who's in the neighborhood as a party to the case. The Hughes versus New Life case, the 2012 sort of pivotal Supreme Court opinion, involved a determination of developer rights, and there was no mass joinder in that case. It simply isn't necessary where the gravamen of the case is not to challenge restrictive covenants, and that was already been decided to not be the gravamen of the case here. Thank you.
Time. Hear from the appellant rebuttal.
Thank you, Your Honor. Picking off where counsel left off, that Hughes decision was a decision that involved a decision by the Homeowners Association at a duly called meeting to make a determination as to what would be part of the covenants, or whether what would be done and the action being pursued that way. In this action, there wasn't a meeting by the Homeowners Association duly called and accounted for to determine that these covenants were going to be overturned. This lawsuit was about overturning the covenants, as it turns out, but again, the courts previously said, no, you can't do that. Now, was there, Mr. Hall, was there a request with this trial judge, Judge Davies? I can tell you over and over again, we had pleadings and we filed and said, if there's going to be an attack on the 2005 amendments in terms of setting them aside and looking at them for any purpose other than evidence and evidence as to some issue, then this joinder is required. So when we had a hearing on that, and again,
was it raised as a separate issue in Haiser 2?
It is a separate issue.
Is it stated as an issue that joinder should have been required?
Haiser 2 indicated that what Haiser 2 said.
I'm asking is, was it raised? Did you raise it? Did either party raise it as an issue in Haiser 2?
Well, I would have to say yes, Your Honor, but I mean because the fact that there was no, number one, there was no joinder. Number two, the 2005 amendments couldn't be attacked at that point.
It's a simple question. I'm not asking why you say that's so. I'm just saying, was it an issue that was actually raised? In other words, was it listed as one of the issues raised for this court to address?
The court states that the trial court should look at the 2005 amendments, and to do that, necessarily, the court would have had to join if it was going to set it. It did. The court, this in Haiser 2 did not say you have to join.
Listen, I understand your argument on why that is so. It's just a simple question I'm asking you. Was it specifically raised in Haiser 2 that joinder of indispensable parties was required? Was that an issue, a separate issue? And I understand your argument why joinder was required and all that, but
I can't say that it wasn't, Your Honor, in terms of that entire, I cannot say that it wasn't. And it certainly was a requirement. If I can touch on this the common area issue really before we run out of time here, there are no plats. This is not a technicality. It's like someone saying, well, I've used your yard, or there's something on your yard. You've got a pool in your yard. I want your yard. And, so we're going to take your yard. Well, no, you can't take my yard. It's mine. It's titled in my private property. It's just like Moy Toy's property. This section, and on top of that, my yard has not been dedicated to this development.
How long has the pool been there?
Specifically, I can't answer that question, Your Honor. If it said specifically in there, but there were other pools. There's testimony there was other pools at that location. So it wasn't necessarily something that was guaranteed to anyone. And on that issue,
But
my
the
client.
residents used the pool up until the time that your client decided they couldn't, and that was, they had used it up until then. Is that a fair assessment?
No, Your Honor. The evidence was before my clients purchased the property, that pool and tennis court and what hadn't been maintained, the whole subdivision hadn't been maintained. And so the prior developer had allegedly, not maintained it, and it couldn't be used, and it wasn't open, and that was some of the complaints. But, that doesn't have anything to do with, as far as it was on the private property of that developer. It was in.
That's kind of like the whole reason why, as I understand it, these folks sort of banded together because they had a neighborhood that they had roads and they had a pool and they had upkeep of roads and lights and like you would expect in a neighborhood, and then all of a sudden that stopped. And that's when they said, wait a minute, who's supposed to be doing this? They're not doing it. Is that not the gist of the whole law?
Those who complain, Your Honor, that's correct. But remember the initial section that I cited out of Haiser 1 or 2, where there's an antagonistic group. There's a group up there that doesn't support the Appellees, and then the Appellees are just, they're determined that they want to get something for nothing. Okay, they're determined they want to take somebody's private property. They're determined that they want to overrule and not pay attention to the covenants, which say particularly that if there's going to be common property, it has to be platted so that we know where it is. They have no description of where that property is. No description, no meets and bounds. There's no exhibit that says it's here.
Homeowners pay dues?
I'm sorry?
Are they required to pay dues?
There are dues requirements for the homeowners associations for the properties that are part of the homeowners association, and where this pool or tennis court is has nothing to do with that development. It was never dedicated to that development. It's like, again, my analogy. They're coming to my house and wanting to say, I want to use your pool. Well, okay, I'll let you use it today. That does not guarantee you a right. You get to own it now, ma'am.
What does the HOA own?
They own. Well, it doesn't all. What do they control? They control the platted subdivisions within that development, and period. That is it. The owner, those who live there can drive on the roads, but that's it. There really aren't any amenities at this property.
what did the dues go for?
The dues went to road maintenance and paying for administrative actions, keeping property clear. There's snow up there on the mountain, snow removal, things like that. Maintenance, basic maintenance. Now, the record indicates.
Is there any proof whether or not any of those dues went to maintain, for example, the pool?
I can't say that there's anything in the record that reflects that, Your Honor.
You've used your time.
Thank you, Your Honor.
Of course, thanks to counsel for both sides. We appreciate your briefs and your oral arguments on this. We'll take a brief 10-minute recess to allow for IT people to set themselves up.
I'll rise. This court is in a 10-minute recess.